But in a way, Dr. Singhvi, I think what happened in the UK is really, in that sense, not in that. I was just talking to Justice Kaul, is not really in that sense in all fours with what happened in India.
Not at all.
The HRA in the UK was intended to enforce treaty obligations under the ECHR.
Yes.
Right? For us, we've always had the overarching principles of the Constitution, which lie above.
That's the irony. We are a for sure, Manoj, with respect. I'm saying on interpretation, this case is cited and the article is cited only for an approach to interpretation.
And, we are not here using the Constitution or utilizing the text of the Constitution to either read down a statute or to strike down a statute. That's one element of the impact of the Constitution. The other thing which we are doing now here is expanding the meaning of a statute in the context of constitutional guarantees. And in that, you are saying be liberated from the bare text of the Constitution or the notion of parliament.
First part of what I argued yesterday was dignity, non-discrimination.
See, in the backdrop of constitutional interpretation, we have never used the originalist doctrine, right? India, unlike what Justice Kalia said, we have never regarded ourselves as bound by an originalist interpretation.
Kalia is an extreme example.
In which case, Dr. Singhvi, if we have never been bound by an originalist interpretation of the Constitution, should we be bound by an originalist interpretation of the statute? Which is in that sense subordinate to a Constitution.
And he knows that a court of one. He said, if I'm the only one, I'll always stick to this original intent. Court of one. So, absolutely. Your basic, all that I'm saying is, one, because I've done the constitutional aspect, yes, unless your lordship anchors it in the values of 14, 15, 16, 19, 21. That's the first part.
But to put it really bluntly, is the relationship between a man and a woman so fundamental to our law and therefore the Special Marriage Act that for us to comprehend that it will also include a relationship between a same-sex couple would be completely redoing the tapestry of the legislation.
So this is
say yes, then obviously we cannot.
The underlying agnostic thrust is the underlying agnostic thrust of SMA, antithetical to your lordships recognizing what Article 14 normally will always include, namely same-sex persons enjoying the same importance and benefits of marriage as different sex persons. That's the long and short of it. As an aid to interpretation, I've only cited one case which says, and the only interpreted statutory were out of the Constitution. Does the underlying thrust, alternatively, an interpretation of SMA, prohibit or preclude your lordship from doing so? Or is your lordship's institutional capacity so compromised by a particular case that your lordships cannot do it? That's the fourfold way, connecting yesterday and today.
And really your argument is that, the institution of marriage in itself is so very important that to deny it to same-sex couples would be really contrary to fundamental constitutional values.
Sorry to interrupt my Lord the Chief Justice, because my note yesterday, I said it, para 15 lists 7 important indicia of marriage and the appendix lists more. Their counter says so. I rely on it heavily. The question is only exclusion. You have it for that side of the table, you don't have it decided. Para 15 of my submissions. My Lord was kind enough to note it down also by hand. Now there, without that, if I was to straight away jump into an interpretation exercise of Ghedan, it would be wrong on my part. I'm completing my argument.
Right, we're just reminding you it's 12:17. Now Ghedan is over, this article is done, we got the trust, now what's the next one?
The next trust. Now let's very quickly. One, I'll be very pointed. Justice Bhatt put a question to me about Justice Lahoti's order. That's 2005, 3 SCC 313.
The tested is
Don't bother, I'm giving a copy to your lordships. Just note, it was a different case. Bhatt said so yesterday. It's a different case. Context was different. It was really about, again, a tenancy law invoked by...
This was in the absence of the domestic.
Deserted wife to claim tenancy, etc. But leave that one. Para 1, your lordship will note, the words are evocative. I'm just moving on. Just para 1 of that.
Dr. Singhvi, what exactly? 2005, 3 SCC?
2005, 3 SCC, 313. Just note para 1. I'll read it fast, fellows. Lordship need not open it. I'll just read it for lordship. Only para 1. The Lord, it connects with what I'm saying. And therefore, your lordship put this question to me yesterday. The law does not remain static, it does not operate in a vacuum. As social norms and values change, laws too have to be reinterpreted and recast. Law is really a dynamic instrument fashioned by society for the purpose of achieving harmonious adjustment, human relations by elimination of social tension and conflicts. I'll leave it at that, Malas. That's just a... The second thing, Malas, my Lord Justice Bhatt put to me. My Lord, remember that passage, so I've traced it out. That's only. Secondly, my Lord put to me.
It's our Gaidan moment in a different context. Our Gaidan.
This is a kind of a Gaidan. I mean, it's a little. Your Lordship is right. That's a tenancy case. But
you see, the interesting part is this predates the domestic violence in Act.
Domestic. That's what the Lordship put to me. That's the point. That's the point. So they well, static, dynamic, moving. That's the whole point. Second, my Lord put a question which will have to await research. I can't give a Lordship a different, but was one of the examples I found. For example, in one narrow case of standard personal accident insurance, what my Lord put to me, is there a statutory regulation? There is by IRDAI, not in the mass of others, but in that, which use the phrase legally wedded spouse. Now, I will make that chart and give it later. I am not considering, suppose your Lordship were to hold that SMA includes this form of marriage. They would be legally wedded spouse in the sense that your Lordship, after your Lordship's date of may fall within that again. But that is one of the few regulations which has the phrase. The large bulk doesn't. Where that phrase is there, it will depend, Malas, on your Lordship's judgment. But your Lordship's judgment, according to me, even where it finds same-sex persons in marriage valid, would be covered under that. I've given you a specific quote of a particular, Malas, IRDA regulation. The third thing, Malas, is how to apply this gender. Malas, the third thing is, just note in bullets, Malas, the answer on this. This is important. Your Lordship has one situation about 2B and the first schedule of the Act. Answer, both parts of both schedules will have to apply to, Malas, non-heterosexual couples. The prohibited category yesterday Your Lordship discussed.
Yes.
Both parts of both schedules will have to apply to non-heterosexual. It does no violence to your Lordship's sense of Malas that your Lordship is making a statutory scheme. Nothing. The statutory scheme exists. My Lord is not saying whether he and I are prohibited category. Whether he and I are prohibited. Lordship is not defining. Your Lordship is saying it will apply on both parts. That's answer number one. No violence to the underlying
Can you
trust.
say that again? Can you say that? Repeat that.
Yes. The two schedules in question for the issue of prohibited degrees of relationship will apply, both of them simultaneously, to all non-heterosexual couples.
That's what Mr. Rotigi said.
That's right. So we are now ironing out your Lordship.
Collapse into one.
Yeah. Suppose your Lordship has to make out a prohibited relationship. That would be legislation. Suppose your Lordship, I am asking to do something which creates something. Nothing. Your Lordship is reading in something and making it as harmonious. Second, 4C, age. 4 items. One I've done with prohibited degrees. Second is age. There are the 4 questions here, Malas. Age, the simple and the correct solution is, Malas, that whichever of the same-sex couple is involved, that age will apply.
Sorry?
First is prohibited degree. I have both. Second is, Malas, age. Whichever of the same-sex couple is involved, whether it is 2 ladies or 2 men, that age will apply, be it 18 or 21. I'll come to the gradations in a minute. Give me a minute. Without having any stitching to be done on a legislative cloth. Third, now the question may arise, what about trans categories? The trans categories, my your Lordship will hear other people are there. My own humble submission would be, in 99% trans categories, your Lordship is able to slot the person as per the gender which he or she professes, says belongs to, claims, etc. Because a trans means a man's body but inclined to be a woman, or vice versa. So if your Lordship were to then follow that slotting, and if the person is a man, otherwise biologically in leaning towards the feminine side, then the age of the feminine will apply, or the age of the male will apply, vice versa. The fourth point here is, brothers, the fourth point is that your lordships, brothers, will keep in mind that I am focusing on what, brothers? What is all these petitioners? They are focusing on the discriminatory parts of the provisions. We are not challenging every provision or interpreting every provision. We are challenging the discriminatory portions of the gendered provisions. Gender provisions which are so we are not, brothers, concerned with every provision. And certainly the government of India is not challenging any provision. So your lordship will see only, brothers, our challenges or our reconciliations where necessary. Fifthly, brothers, some provisions which may not create any confusion, like 27(1)(a) of the SMA, only an example. They are peculiarly, conceptually, designedly created and applicable only to heterosexual relationship. Rape. I mean, you cannot, brothers, have a system which applies uniformly to every category.
No, why?
Discrimination.
Rape.
Why can't it apply to a
No.
homosexual couple?
No, with a caveat. Well, it's a criminal offence which has been defined. I will find the shortest definition is non-consensual penile vaginal penetration. It's one simple way of putting it. Now, of course, it has been expanded after the Verma committee to mean other forms of molest. But otherwise, non-consensual penile vaginal interface. Penetrative. Now, it is true that as well as rape, apparently rape is a crime even by a woman or a man in France, as far as I know. Those are special cases. Today, your lordship's issue is, can your lordship not move forward by these kind of possible obstructions?
And then we admit that in this case it will apply to one kind of one kind of same-sex partner. This marriage offence,
Yes.
it's a marriage offence, will apply to one kind of same-sex partner.
It is possible. I'm only saying it differently because it's a crime. According to me, it will be covered in a penetrative same-sex situation also.
No. What?
But it's a crime. A crime would have to be
we are talking of outside of the marriage relationship. When you indulge in that, that's a matrimonial offence, entitling the other spouse.
No, it will be only if a lordship holds this marriage. The lordship will have to hold this category of unions to be a marriage first.
That's right.
Then the question will arise.
Testing.
Yes.
We're testing that if.
Yes, correct.
Then it will apply to one class of same-sex.
No, therefore, there are two ways. I mean, I concede there are two ways. One is that if your lordship holds this class to be covered, then your lordship would have 27 applying to penetrative assaults.
Then in this.
No, even with the same sex. Even with the same sex. That's the logical conclusion. Alternatively, your lordships could draw a line saying it's a criminal offence which has been defined in a heterosexual context. These are the two options. I can't say about.
Then we have three categories, really speaking. We accept the first option which you are offering, which is that A, it applies to.
If it otherwise satisfies the definition.
But it will not apply. So there are three meanings to the same enactment.
Is from moving ahead.
No. It applies.
These are
to the extent it applies.
There are some peculiarities.
In a heterosexual relationship,
Yes.
say there can be possibility of reading a rape into it, then how can in a homosexual relationship it not be read?
Not be read.
Well, I'm saying in fairness, I started by saying that. Well, in logic, no. In logic, no.
Okay. There's a conundrum.
Logic, no.
Mike, please.
I thought I said in a heterosexual relationship, if in case of a married
Logically,
couple,
no. Correct.
there can be rape, then how is it possible that we don't have a scenario where in a homosexual relationship the same principle will apply? The same principle.
So, if your lordships were to apply the definition of non-consensual penetrative sex, then it would apply. Logically, that's the correct answer. With great respect.
That's the little trouble of seeing how we get into different sections, how we get into different laws,
Right.
how we get into it. So the debate would be whether we stop just short of saying, you are saying it may be empty, but should we stop short? I'm just thinking
May
about
I answer it?
just saying that this is under this act, such a marriage is possible and registered. Thereafter, there may be many nuances which will arise.
No,
Can we take care of all future eventualities?
there is one flip side to it. There is a flip side to it. I'm sorry, I'm not completed yet. Well, this is important. I'm not completed. Well, marital rape is not recognized yet in this country.
That's right.
Marital rape, that's the fourth one.
That's an issue. pending.
That's the issue pending. Today the law is not marital rape.
No.
Therefore, once your lordships were to read marriage,
There are people who are wanting us to move in that direction also.
There are
Wanting us
matters
to move in a
pending.
different direction.
that's a different.
Not
That's a different debate.
Marital rape too.
Today, as of today, rape, there is, it's not a recognized crime within marriage. It's maybe a ground for divorce or some cruelty. Cruelty is a better way of putting it. But now my point is different.
The High Court judgment.
Karnataka High Court
Karnataka
judgment.
That's an outlier in the sense that your lordship is still debated. It's not a law of the land.
This court has not taken a view on
You
it.
view it, yes.
There's
But I'm on a different point.
view.
If your lordships, this bench were to recognize the issue we are canvassing, within the marriage which your lordship recognizes between same-sex persons under SMA, your lordship would be recognizing marriage within this act.